common estate planning mistakes.
I think I made a mistake.
Don't make these. Failing to plan, not discussing your estate plan with your family and your friends, naming just one beneficiary, forgetting about your financial power of attorney, forgetting about your healthcare power of attorney, forgetting about your final arrangements, your funeral, forgetting about your digital assets, forgetting about the charities that are important to you, not thinking about your children's futures, not funding your trust, not storing your estate plan in a safe place where somebody can find it, forgetting to update your estate plan. Don't make these 11 estate planning mistakes. First, congratulations, because if you're watching this video, it tells me that you have either created an estate plan or you're in the process of creating an estate plan. Either way, it's important to avoid these common estate planning mistakes. You do not want to go through all the hard work and all that money of creating an estate plan only to find out that it's ineffective for what you wanted to happen, or maybe even causes your family more problems. Let's go over the common estate planning mistakes that we see all the time. The first is failing to plan, not doing anything at all. And unfortunately, we see this a lot. People say, well, I don't care what happens after I die. And you know what? To a certain extent, I get that. But if you fail to plan and you really only wanted your assets to go to a particular family member, or maybe to a charity, or maybe you wanted to stay in your house as long as possible, all of that is part of your estate plan. And if you don't have an estate plan in place, when you pass away, the state that you live in will most likely have a last will and testament written by the legislature in your state that says what will happen to your assets. And it may not be what you want. It may be divided between 18, 20 cousins that you never even met before.
So tell me, stranger, who are you exactly?
Because you did not have an estate plan in place. It may not go to that charity that you've been supporting your entire life because you don't have a plan in place. And what's even worse, what you hear about me talk about all the time, is not having an incapacity plan in place. If you don't make a plan, then most likely your family, a friend, whoever it is who's caring for you, is going to have to go to the courts and get a guardianship over you, a legal guardianship. So if you don't have a plan, it not only affects what happens to your assets after you die, but it also affects what happens to you during your lifetime. So you need to have a plan in place. That's the number one biggest mistake. Have a plan. Number two, not talking to your family and your friends about your estate plan. Now, there are exceptions to this. You may not want them to have the complete detail of what is in your estate plan, but you really do need to at least give them an outline. I always tell people that I owe my fiduciary, I owe my duty to them as my clients in creating their estate plan. But a lot of times it is helpful to at least have some of the family members come in and let them know what you are thinking in your estate plan. And sometimes it is taken a little bit easier when it comes from the attorney instead of from mom or dad, right? And I can understand that. Mom and dad, you don't want to exclude somebody, or you may have very good reasoning why you want to do your estate plan the way you want to. And the thing you have to remember is that it's your estate plan. In most jurisdictions, in most states, there is no statutory requirement that you have to give your kids anything from your estate plan. Now, I've said in other videos that if you do not want them to have anything, you do need to specifically disinherit them, saying, I don't want to give Johnny anything. But if you don't want to give them to him, then don't. It's your decision. But at least talk to your family and let them know what your plan is. Give them a general outline so that when you do die or when you become incapacitated, they have an idea of, one, who is in charge, what's going to happen, what did you want to happen. Communication is key to making your estate plan work the way you wanted it to work. Naming just one beneficiary. We see this a lot, especially with parents, either a mom, father, whoever it is, who has an only child. And their thinking is, well, I don't need to do an estate plan. I don't want my estate to have to go through the probate process. So I'm just going to put my son or my daughter, everything. They are the beneficiary. So on their house, they put them as the joint tenant on their house. You do that, yeah, that'll work, but you also have to be concerned with capital gains. So talk to your CPA or your accountant if you're going to make that change, because you could trigger a sale in the eyes of the IRS and create a capital gains event. So make sure that if you're going to do that, you do it correctly. You know, I always say that if you want your house to go to your child, put it in your last will and testament, or even better, put it into your revocable trust and have it distribute that way so that they get the stepped up in basis. Same thing with your bank accounts. If you have a bank account, a lot of times parents with an only child will just say, well, I'll just put Johnny on there, then I don't have to worry about it. But what happens if Johnny Johnny predeceases you? What happens to your money then? What happens if you and Johnny are in a car accident together? You pass away, and so the second you pass away, that bank account goes to Johnny. But then Johnny also dies a few days later. Who gets that money now? It may go to his wife who you didn't like, or it may go to a child who you didn't like. And you have to have backup beneficiaries if you want all this to work. So if Johnny is really who you want it to go to, and you want to do a simple plan, and you just have all your distributions on your insurance policies, your bank accounts, even your house with a transfer on death deed, make certain that you have a backup in case your son, Johnny, is no longer around, he predeceases you, or dies before getting his distribution. Who is going to take his place? Very, very important. People never think about that backup beneficiary, and that is a very common mistake that people make. Failing to think about your financial power of attorney. You hear me all the time talk about a revocable living trust centered estate plan creates an umbrella of protection around you, over you and your family. One of the most important documents in that revocable living trust package is your financial power of attorney. If you were to become incapacitated right now, this second, who takes over as CEO of your finances? Who's going to be taking over what happens to the house, to your bank accounts, to your IRA, to your 401k? You're alive, so somebody needs to have the authority to act on your behalf as your fiduciary and act in your best interest to make certain that those funds are utilized in the manner that you want them to be used for, to take care of you during your incapacity. Very important to have a financial power of attorney in place, in addition to all the other documents in your revocable living trust centered estate plan. Forgetting about your health care power of attorney. Those other documents are very important. Your trust, your pour over will, your financial power of attorney, but they all deal with your finances. What happens with your health care? You always hear me say mind, body, and soul. Who is going to take care of you? Who is going to look after who sees you? What doctors you see? What medications you take? What treatments you're going to get? All of that is extremely important to making certain that you live your life as comfortably and healthy as possible if you are to become incapacitated. So you have to have healthcare power of attorney in place to make certain that what you want to happen for you, mind, body, and soul, is going to happen exactly how you want it to happen. And along with that document, we also include an advance directive and your HIPAA authorization. What do you want to happen if you're in a persistent vegetative state? Do you want food, water, pain medication? Do you want to be hooked up to the machines? That's all your decision. And your HIPAA, who has access to your medical records? Now, I always say put one person in charge as your healthcare power of attorney, but maybe you want to name a committee who has access to your medical records, who can at least advise that healthcare power of attorney on what they think. Maybe you do it, maybe you don't. But remember, this is your decision, not anybody else's. Forgetting about your final arrangements, your funeral. What do you want to happen? A lot of people don't want to think about this, but I can tell you from personal experience and from doing this for over 20 something years, how big, how huge of a gift this can be to your family for you to plan your funeral. Make your own funeral arrangements. Maybe you don't want a funeral. Maybe you don't want a viewing. Maybe you want to be cremated. Maybe that you don't want anybody to, there not to be any party. Maybe you want a huge party. Maybe you want to leave $10,000, $20,000 left over just to have a party so that people can celebrate and have a drink to you and to your life and the enjoyment that they had knowing you. But this is all your decision. And I can tell you again from personal experience and the years of doing this, that if you can do this, if you can plan all this for you, it is a huge gift to your family because they are going to be grieving and it's not an easy time. But if you've made all those decisions ahead of time, it's going to make it just a little bit easier for them. And it could be that little bit that lets them grieve properly and get through the process of remembering you. So in addition to your estate plan, make certain that you have your final arrangements made where your family can easily access them when the time comes. I always tell my clients, put your funeral arrangements in your binder, in your estate planning binder, where they can find it when they need it. Having a plan in place for your digital assets, Facebook, Instagram, TikTok, whatever it is. If you have social media and you have an active social media life, then you really need to appoint somebody as having the authority to act on your behalf, either when you become incapacitated or when you pass away, regarding your digital assets. I can tell you there's nothing more uncomfortable than going to somebody's website or to their Facebook page or Instagram page after they've passed away and you still see people commenting and not even knowing that the person has passed away. So make certain that you have a plan in place for your digital assets. Have one person, maybe it's your person who you put in charge of your trust or your executor of your will or your power of attorney, but make certain that you have a plan in place for your digital assets if something were to happen to you, either for incapacitation or if you were to pass away. Very important these days to have a plan in place for your digital assets. Forgetting about charities that are important to you. If there's a particular charity or several charities that you have been providing for, supporting during your lifetime, then you might really want to think about supporting them after you pass away. If it's a school or university, I've had some great folks recently who have created scholarships at the university where the husband went and the university where the wife went. And I think this is a fantastic way to provide their money, and people who they never even met are going to get to enjoy that money, help them with their education, and further that area that they worked in their entire life. So very important. Don't forget about your charities. Not thinking about your children's futures. There's a few things that I can think of off the top of my mind here. And one is, what if your child is receiving government benefits? Maybe they're on SSI or some other type of government benefit. And if they are, giving them a lump sum of money could mess up their benefits and maybe stop their benefits for a while until that money gets used up, and then they can go back on the benefits. So if your goal is for that money to be used as a supplement, then talk to an estate planning attorney and make sure that you set up a supplemental needs type of a trust, so that money just supplements but does not affect in any way their government benefits that they might be using. So very important. You really need to think about your children's futures if they're in that kind of a situation. Another one is, what if your child predeceases you or dies before receiving their total distribution? Who gets their money? You want it to go to their kids, and if you don't make that plan in place, it may end up going to their spouse who you didn't like. So make certain that you have a plan in place. What if they get a divorce and his or her spouse ends up getting half of your assets when you really wanted all of that to go to either your son or to your grandchildren? That's very important. The third one that I can think about there is, what if your son or daughter has a substance abuse problem? If you're going to give them a lump sum of money, whether it's $1,000, $10,000, $50,000, and if they have a substance abuse problem, whether it's drugs, alcohol, whatever it is, where do you think that $50,000 is going to go? It's not going to go into their bank account very long. I would say probably they're going to use it for drugs or for alcohol, and that money that you worked your entire life for is going to get blown very, very quickly. If your child is on government benefits, if you don't like their spouse, or they have a substance abuse problem, then really think about your children's future and how you want to structure your trust so that they get the money the way you want it to get used and it doesn't get blown immediately. Not funding your estate plan. Funding is vital. It is absolutely vital to fund your revocable living trust correctly so that all of your assets are in the name of your trust, or maybe they flow to your trust or distribution to your beneficiaries. And this is very important, because if you bought a little rental house that is not in the name of your trust, then that rental house is going to have to go through the probate process. Probates are expensive depending on where you live. They could run between $4,000 and $10,000 easily. So you want to make sure that if you have an estate plan, if you have a revocable living trust centered estate plan, that it is funded correctly with your real estate, with your vehicles, with your bank accounts. Anything that has a title needs to be into your trust. Talk to an estate planning attorney so you make certain that this is done correctly. Failing to properly store your estate plan. You go to your estate planning attorney, you work really hard to create this great plan, you spend money on it, then where does it go? You need to keep it in a safe place. I tell a lot of people, go and get a fire safe at Walmart, Home Depot, Lowe's, wherever it is, and get a fire safe and put it in there. If you don't trust those type of safes, then get a safety deposit box. Although safety deposit boxes can make things difficult when you pass away if somebody does not have immediate access to it. So think about that. Talk to your bank to make certain that whoever should be able to get to it can get to it. And let people know. If you have a successor trustee or an executor, personal representative named, tell them where these documents are. In almost all jurisdictions, the courts require original documents. You can't just show up with a copy of a last will. You have to have the original. Make certain that you store your estate plan properly and you let the people who need to know exactly where it is and make certain that they can access it when they need to access it. And the last and probably the worst common mistake that people make is failing to update their estate plan. You spend all the time, all the money, meeting with attorneys, getting your estate plan exactly how you want it, and then in 5 years, your life completely changes. And that estate plan no longer makes sense for the situation that you are in. Maybe you moved, maybe you got divorced, maybe you got remarried, maybe your children had children, maybe you adopted a child. There's all kinds of things that can affect your estate plan. And so you have to make certain that your estate plan is up to date. One of the biggest mistakes that I see people make as far as that goes is, well, I can think of two. The first is they get their first job someplace. Maybe the parent got their job in the 70s or the 80s, and they went to the HR department. They were not married, they did not have children, so who did they name as the beneficiary on their company's insurance policy and retirement and all that? They probably named their parents. And then they got remarried, then they had kids, and now they are in their 60s and 70s, and those documents that they signed at the HR department in the 1970s still list their parents as the beneficiaries. You have to update your estate plan, whether it's beneficiary designations or it's your last will or your revocable living trust. If you get a revocable living trust centered estate plan, you really should make an appointment with your estate planning attorney at least once a year and see what is going on in your life. Talk to them. Things that you may not think are important will be a red flag to an estate planning attorney, and they'll say, hey, we need to adjust your estate plan because of what you just told me. Or, hey, if this continues, we may need to revisit your estate plan to make certain that your grandkids are taken care of. So an estate plan needs to continue to grow with you, because if you leave it alone, if it becomes a stale old sandwich that nobody wants to eat, it's not going to be helpful when the time comes, because it's going to name the wrong people. It's going to maybe give money to people who you didn't want to. Maybe they've passed away. So even if they've passed away, that money still goes to their estate. And maybe their estate goes to people who you don't even know or would never want your money to go to. So you have to make certain that you keep your estate plan up to date. Go to your doctor once a year for a checkup. You should be meeting with your insurance provider to make sure you have the correct insurance at least once a year. You should be checking on your finances with your financial advisor. You should be checking with your CPA or your accountant and your estate planning attorney, and visit all of these people to make certain everything is up to date and everything is where you want it to be. Creating an estate plan, an umbrella of protection around you and your family, is one of the biggest gifts that you can give your family. It takes a lot of work. And if you're going to put the work into it, you're going to put the time and the money, like I've been saying, then you need to make certain that you keep it up to date and you don't make any of these 11 mistakes, common mistakes that people make on a regular basis. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that, so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button, and also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.